Hi, my name is Akiva Goldman. I'm an attorney with Goldman & Associates. I'm the founder and director of the firm. Our firm primarily focuses on family law. Please subscribe to our channel. Today we were asked a question by our viewing audience: is there a way to avoid mediation? Mediation is a process by which the court will typically order the parties before going to trial to make best efforts to try and settle their case by meeting with a court-appointed mediator who, and when I say court-appointed, I don't mean court-sponsored. I mean the court might order a person be a mediator and then it's paid for by the parties. I'll get into that in a minute. But the court will do that in an effort to in some way to try and get the parties to settle their case without going to court. It's sort of like an in-between step. You've got your lawyers, you've got the case going on, and you got the judge, but in between your lawyers and that judge, there's another functionary whose job it is to try and bridge the gap. Many courts will order this in domestic cases. Just because they order it doesn't mean they pay for it. Typically the parties are going to have to pay for it, sometimes equally, sometimes not. But that mediator is usually a lawyer. It's usually someone that either the attorneys know, who's an expert in family law, or it could be somebody that the judge knows and the judge feels is instrumental in settling cases. We do a lot of mediation here in the office as well, so I know very much about this process. Can you avoid it, was the question that a member of our audience asked. And you really can't, because even if you have a case that cannot be resolved, that is going to result in having to go to trial, and therefore you don't think it pays to pay lawyers to participate in the mediation and pay the mediator and all that, the court is probably going to order it anyway. And if the court orders it, you don't have a choice. You've got to go and you've got to make a good faith effort. The last thing you want is for the mediator to report back to the court that the parties made no legitimate effort to try and settle the case. The court's going to order it for this reason. The court knows at the end of the day it's going to make a decision about your divorce, about your custody case, whatever it is. The court also knows that experienced lawyers who are before the court on a regular basis probably already know what the court is going to rule. In light of that, it should be easy for a mediator who likewise knows the same thing to get the parties to say, look, this is what's going to happen in your case. Now, you can spend $20,000 trying the case and come up with that same answer, or you can save all that money, save the trial prep and the trial expense, agree to it now. And it's always better to agree than to have some kind of black robe tell you, you shall do this, you shall do that. Even if you begrudgingly consent, it's still a better way. It's you controlling your destiny, your child's future, your family's security at the end. It's you in charge. Once you leave it in the hands of the judge, you don't know what's going to happen. So that's the theory of it. Can you avoid it? No. If the court ordered it, you can't avoid it. You're just going to have to comply. Having said that, if the court hasn't ordered and it's suggested to you that you do that, of course, you can tell your attorney, you know what? I don't want to go there right now. I'm going to keep going forward with the litigation unless the court orders it. You got to realize, though, that certain judges, their reputation for sending cases to mediation is legendary. The attorneys already know that if they can't settle it, the court's going to order it. And if that's the case even before that order, you might as well get ahead of it and participate in that process. And at least then you can tell the judge, you know what? We tried it. It didn't work. Give us a trial date. If you have any questions about that, reach out. Of course, we'll be glad to help you out.